Thrilled to welcome you all to this briefing on the need for the Securities and Exchange Commission to move forward on their rulemaking on corporate political transparency. I'm Lisa Gilbert, Director of Public Citizens Congress Watch Division. Public Citizen is a national membership-based nonprofit. We work on issues like consumer protection, banking, and good government. We also work as a part of the Corporate Reform Coalition, which is an 80-plus organizational coalition. Nonprofits, investor organizations, and academics all gathered together to work towards political spending transparency. We're going to start our event with remarks from Senator Bob Menendez of New Jersey and Senator Elizabeth Warren of Massachusetts on the need for this rule. Both are, of course, esteemed members of the Senate Banking Committee and longtime champions of consumer issues and investor issues. Many thanks to both for taking part today and being such champions. Turn it over to Senator Menendez.
Well, thank you, Senator Lisa, for your introduction. I'm thinking about Senator Warren. We could use another Senator Lisa here who would help us with this disclosure issue. So, Senator Warren was sitting behind my nameplate, and I said, "You have increased the intellectual ability as well as the good looks of Senator Menendez." So that's the Rutgers Law School end of the table. I understand there's a Harvard component here. So let me thank your organization as well for the work in organizing the event and for your advocacy on this issue. And to Senator Warren, who's been a fantastic voice before she came to the Senate in her roles of creating the Consumer Protection Bureau, and ultimately she has brought that same vigor to the Senate Banking Committee, which has been extraordinarily welcome. And to all the distinguished participants on the panel, I'm going to, after my remarks, listen to Senator Warren, and then I have the Prime Minister of Iraq, so I'm going to have to leave after that, but I do have staff here who I want to listen to the panel. And your panel has some of the nation's leading governance, corporate governance scholars and representatives from the investor community who are here to basically discuss what I still believe very strongly is a critical need for corporate disclosure of campaign spending. Disclosure of corporate political spending has, in my mind, very clear value for our democracy. It comes in the form of transparency. It comes by cleaning up campaign finance, keeping the election process free and fair of superfunded outside influences here in the United States or from elsewhere. According to Open Secrets, outside groups spent more than $1 billion in the 2012 federal elections, which much of it funneled through trade associations and nonprofits with minimal disclosure. But even if you set the benefits to our democracy aside, which obviously are primary for me, the case for disclosure is still clear and convincing. Purely as a matter of corporate governance and investor protection, I think they are compelling. SEC Chair Mary Jo White has spoken recently about focusing corporate disclosure on providing investors with the information they find necessary and material to make informed investment and voting decisions. In this case, while disclosure of corporate political spending has important social benefits, it's also, from my perspective, a no-brainer simply in terms of good corporate governance and investor protection policy. And as I expect our panelists will discuss, this information is very material to how shareholders decide where to invest their money and how to vote in corporate elections. It's simple. It's shareholders' money, and they should know whether the corporate managers who work for them are spending it for political purposes, and if so, what are those purposes in terms of, is it aligned with the corporation's interests? Is it aligned with the shareholder interests? Is it aligned with their values under which many investors ultimately decide to invest, particularly when you look at pension funds and other entities that become major investors? And so it seems to me that for those who argue against this, it splits both ways. You might have shareholders who say, yeah, I believe in that spending because it may, from my perspective, ultimately create the advocacy on policy or individuals who will ultimately improve the shareholders' bottom line. That might be a view. The other view might be that, no, I don't believe that this is an appropriate use of shareholders' monies because it's not aligned with the company's interests, it's not aligned with the investor's social values, it's not aligned, in essence, with the very core of what an investor is looking for in their company. So I can make the argument either way, and either way, transparency is a good thing. As many of you know, after the Supreme Court's Citizens United decision, I introduced the Shareholder Protection Act to require public companies to disclose their political spending and to require a shareholder vote to approve it. I think it's common sense legislation, and I want to thank Senator Warren for her co-sponsorship of the bill. But even under current law, without that legislation, the SEC does have the power right now to require corporations to disclose their political spending to investors. And it has received a record number of comments, 640,000 and counting, urging it to act and use that power. Now, I suspect some of you in this room have been among the 640,000 that may have written, and I thank you for that. And I want to thank Professor Robert Jackson for his leadership on this issue in submitting the initial rulemaking petition urging the SEC to act, and our panelists for their leadership on this matter, which I think is critical. I never quite understand how ultimately disclosure transparency is a bad thing. And I do not accept that it is so onerous on the companies as so to undermine their ability to be successful financially. I do think that it is important for shareholders to understand what their company is doing that they are making investments in as it relates to the shareholders' investment not only monetarily, but in what they believe that company is all about and what it should ultimately stand for. We've already seen some examples of some companies that made investments in candidates who supported positions that were totally adverse to the broad understanding of what those shareholders hold as their values and reacted violently against it. It is the ability to simply do that, to have that information in the first instance that I've urged the SEC chair to use, even though she is being browbeated by a whole host of individuals, particularly on the House side, against using that effort. I think that our collective voices as citizens are incredibly important to assuage her to understand that the power that is there is one that should be used at a minimum. Thank you very much for that.
Today, my job today is just to push. That's what I'm here for. And I want to push Senator Menendez's bill. I want to push the SEC, and I want to push all of you to push them. So I want to start this by saying thank you very, very much to Senator Menendez, who has shown incredible leadership in this area. I knew the senator many years before I ever had a notion that I would end up running for the United States Senate, in his work in standing up for consumers, in his work in standing up for just ordinary people who wanted a level playing field, who just needed a shot at being able to have a little information so they could make some good decisions. And through that work, now to see where Senator Menendez is on this particular bill, to say, look, this works across the board. You get the right information so you can make the right decisions. And so I want to say his leadership here has been extraordinary, and I very much want to see his bill passed. So that's where I start this, but I also go where Senator Menendez goes. And that is, we don't have to have legislation for the SEC to do the right thing. They have the power to do the right thing right now. And our collective job is to urge them, push them, harass them until they do the right thing. For me, this one is foundational. Part of the whole concept of putting your money with business and then the business goes out and operates is that there's full and fair disclosure about what's going on. And anyone who doesn't like it can then vote with their feet. They can get out of that business, or they can vote with their votes, their shareholder votes, and put someone else in charge. The idea that a company can say, I'm going to take your money, but then I'm going to spend big parts of it in ways you don't understand, in ways that I am not going to disclose, I think is just fundamentally wrong. It undercuts the basic notions of corporate democracy, but it ultimately undercuts all of democracy as well. We all understand, since Citizens United, the kind of threat we face as a country with corporate influence, with dark money spent in our elections. This threatens the whole underpinning of one person, one vote. Understanding what's going on and being able to vote on that. So this one really matters. It matters for our business world. It matters for our democratic world. And I am delighted to be here today. I want to say to public citizen, yay, for getting out here, and holding this event and helping us have a chance to come together to remind people what is at stake here. I want to applaud Professor Jackson for the work you've done. You have shown us, to the extent you can find the data, you have shown us about the significance of corporate spending on the parts that we can see, and really highlighted how significant this area is. I want to thank all of the panelists, my colleague John Coates, and everyone else who's going to talk about this today. I also apologize because I'm going to have to leave along with Senator Menendez. I'm off to talk with credit unions. I'm learning that you're multifaceted when you're in the United States Senate. But I want to finish where I started. This is foundational. There is no excuse. There is no reason on the other side for saying a corporation wants to be able to spend shareholders' money and not tell shareholders how that money is being spent. A corporation wants to be able to influence the political process, but not have anyone in the public know how that was done. That hits at the core of how our business world works. It hits at the core of how our democracy works. So we come together strongly, we come together with energy to say, we are not going to put up with this. We're going to push on the SEC, we're going to push on Senator Menendez's bill, but we are going to make sure that corporations reveal their political spending. That's what this is about. Thank you.
Thanks so much to the senators for being with us today. We're so happy to have their support, along with 15 other senators who are also pushing for the SEC rulemaking, as well as 70 members of the House who are doing the same. Today, these senators are joined by a really impressive panel of speakers who will share their perspectives on the need for a uniform measure on corporate political spending coming out of the SEC. The Hill publication very recently called this rulemaking the #2 most watched rule out of the 25 top ones winding their way through the regulatory pipeline. We agree. Our speakers certainly take the stage at a pivotal moment for its success. The SEC has already placed the rulemaking on its agenda, consideration of the rulemaking on its agenda, and now the chair and other commissioners are just awaiting recommendations from their corporate finance division and need to take the next steps to move it forward. The petition for a rule on corporate political spending at the SEC was filed by a set of renowned bipartisan academics, including Professor Jackson, who's with us today, following the benchmark Citizens United decision. The decision, of course, has allowed for what the senators mentioned, the new onslaught of undisclosed corporate spending into our system. But the petition is also right in line with longstanding demands of shareholders. The resolution process has been pushing for disclosure over the last 10 years, and we'll hear more about that from our panelists. It's also aligned with what many businesses just want. In a recent survey of U.S. business executives commissioned by the Committee for Economic Development, more than 4 out of 5 CEOs that were surveyed, including 79% of surveyed Republicans and 100% of surveyed Democrat executives, support this type of transparency measure. Since it was filed, the petition for rulemaking has been supported by an impressive array of SEC constituents. This ranges from 6 state treasurers to a group of investors that represent more than $690 billion in assets under management, to pension funds, to small businesses, to public companies, to colleges and universities that represent their invested endowments. The list goes on and on. And of course, as Senator Menendez mentioned, the rule is also supported by the all-time record in public and retail investor comments in the history of the SEC. So we're looking at 643 public comments filed as of now, 643,000 public comments. The demand for this rule from investors is just loud. It's ever present, and it speaks to the material nature of this information. SEC Chair Mary Jo White lately has spoken about the need for the SEC to be independent, stressing that they're the ones who should use their expertise to mandate transparency requirements when information about companies is needed by investors. We just believe that this rule fits that rubric perfectly. The information has been loudly demanded by investors who are asking the SEC for it based on the need they see for the information to make smart investment choices. So because of that, we look forward to the SEC continuing to move the rule. So turning now to our wonderful panel, you have their bios in the information packets that were by the door, so I won't go into great detail as I introduce them, but just introduce them briefly and then we'll get going. Each person will talk for 5 minutes or so, and then we'll open it up to questions from this great crowd. So with us today, as has been mentioned many times, we have Professor Jackson of Columbia Law. He's the Associate Professor of Law, Milton Handler Fellow, and co-director of the Milstein Center for Global Markets and Corporate Governance. Professor Jackson, of course, is also the co-chair of the group of legal academics that petitioned the SEC for this rule. We have Pat Doherty, who is the Director of Corporate Governance in the Office of the New York State Comptroller. Mr. Doherty helps develop and administer corporate responsibility initiatives for the $153 billion New York State Common Retirement Fund. We have Professor Coates, who is the John F. Cogan Jr. Professor of Law and Economics at Harvard Law School. Professor Coates joined the faculty in 1997 after leaving private practice, where he specialized in mergers and acquisitions, corporate and securities law, and the regulation of financial institutions, including mutual funds. We have Heidi Welsh, founding executive director of the Sustainable Investments Institute. She's analyzed corporate responsibility trends for 25 years. SI2 is supported primarily by 17 of the largest endowed U.S. colleges and universities and some of the biggest U.S. pension funds. And then finally, we have Laura Berry, the executive director of the Interfaith Center of Corporate Responsibility, or ICCR. ICCR is a coalition of nearly 300 faith-based institutional investors representing over $100 billion in invested capital. August panel, so with that, I will turn it over to Professor Jackson to kick us off.
Well, thank you very much for that incredibly kind welcome, and I'm very grateful to the senators for their support and to all of you really for being here today to join us for discussing an issue that I think is critical and an issue whose time I think has finally come. And of course, that's the issue of requiring public corporations to disclose their spending on politics to the investors that own the companies. Now, as has been mentioned, I was the co-chair of a committee of 10 law professors that petitioned the SEC to make a rule that would require this kind of disclosure. And as has been mentioned, the petition has received unprecedented support. And I just want to say again how grateful all of us who've been working on this issue are to all of you who've expressed your support. I definitely don't have 640,000 friends, so it's clear that other people are paying attention, and we're delighted actually to have such broad and bipartisan support for this important proposal. And I think there's good reason why this proposal's gotten support. As we explained in the petition, and we've been arguing to the SEC for some time now, their disclosure rules have always evolved and adapted over time in order to give investors the information they need. And there is no question, everybody agrees, that shareholders want to know whether and how their companies spend money on politics. As has been mentioned, shareholder proposals requesting that companies disclose how and when they spend shareholder money on politics is the most popular corporate governance proposal at public companies today. And the fact that shareholders are interested in this shouldn't surprise you. And the reason is that if you look at the amount of money, the amount of corporate spending on politics that's happening today, it's frankly astonishing. If you just look from 2005 to 2010, federal spending only, how much money is being channeled through intermediaries like the Chamber of Commerce and other organizations that can receive corporate money and spend it on politics, you'd find that $1.5 billion has been spent at the federal level alone of shareholder money on politics. and this spending is not revealed or disclosed anytime, anywhere to the investors whose money it is. Now, although these billions of dollars are being spent on politics, it's not clear at all whether that spending is actually in the interest of shareholders whose money it is in the first place. And the reason is that the interest of the insiders, the directors and executives who decide how this money gets spent, their interest in politics might be different than the shareholders' interest in politics. That is, the insiders might spend shareholder money on political causes that they favor personally, rather than those that advance the company's business. Now, the Supreme Court's recognized this problem, and when they decided the Citizens United case, they told us that shareholders could keep an eye on this for us. They said, in the court's words, the shareholders could, quote, decide through the procedures of corporate democracy whether the company should spend on politics, and if not, they could vote out the directors who were spending their money in a way they didn't like. But you see, for shareholders to take that step, they have to be given information about the company's political spending. Without transparency, shareholders can't possibly hold directors and executives accountable when they spend corporate money, shareholder money, on politics. Now, we've actually seen over time that in response to shareholder requests in this area, many large public companies now give their shareholders this information voluntarily. But the problem with voluntary disclosure in this area is that the disclosures vary significantly. It's very hard to compare one company's disclosure to another. And as I think other panelists will mention shortly, it would take an enormous amount of shareholder time and energy to get every single public company to voluntarily agree to provide this information. In the past, the SEC has never required investors to go door to door to get companies to give them the information they need, and they shouldn't do it now when it comes to corporate spending on politics. So shareholders are clearly interested in this information. It's necessary information for shareholders to hold directors accountable for what they're doing with shareholder money, and that's why the SEC placed a disclosure rule on political spending on its regulatory agenda last year. Now, that proposal has drawn several objections from critics of disclosure in this area. And in recently published work, Lucian Bebchuk and I take stock of those objections, and we show why they provide no reason for the SEC to allow this money to continue to be spent in the dark. Before we turn to the other panelists, I thought I'd just briefly explain why 3 of these objections in particular give us no reason for the SEC to remain silent on this issue. First, those who don't want disclosure in this area will tell you that it will be costly for companies to give this information to their shareholders. And this is not a serious reason for the SEC to allow corporate political spending to stay in the dark. For one thing, although hundreds of thousands of comments have been submitted about the petition, and thousands of corporate executives have commented about it, the number of public companies that oppose the petition on that basis is 0. For another reason, those of us who've talked to directors and executives know that for many companies, this information is already available because it's got to be collected and presented to the company's key decision makers. Because that's true, it won't be costly for the company to convey this information to their shareholders. So this isn't a real reason for the SEC to stay silent. Another argument you'll hear from opponents in this area is that political spending is good for investors. And if we require companies to disclose it, they won't do political spending that would be good for shareholders. Now, as I think Professor Coates will explain, it's far from clear, as a matter of the empirical evidence, that political spending is on average good for shareholders. But even if you believe that it is, even if you think political spending is good for shareholders, the increased accountability that disclosure would provide would still improve the alignment of corporate spending on politics with shareholder interests. And there's absolutely no reason to think that disclosing this kind of spending is going to keep companies from engaging in the political spending that actually is good for shareholders. The only type of spending they won't continue to do is the kind that's bad for shareholders. And that's not a cost of disclosure in this area. That's a benefit. The last opposition you'll hear, and this is the key argument I'd really like to make sure folks don't take seriously, is that the SEC shouldn't go into this area because it should stay out of politics. As a matter of fact, one of the sitting commissioners, Commissioner Gallagher himself, has said that the SEC should stay out of this area and that he's going to oppose any rule in this area. Press accounts have actually hinted that the SEC staff are worried that they shouldn't get involved in politics. And let me just say, whatever position you take on corporate disclosure, on disclosure of corporate political spending, the SEC should not fail to give shareholders the information they need, because doing so might have implications for politics. It's the SEC's job to make sure that companies give investors the information they need to value the companies they own. When they do that job, the SEC and its staff should avoid speculating and should resist speculation from outsiders on Capitol Hill and beyond about how requiring that disclosure could influence politics. Now, of course, the SEC shouldn't make a rule in this area to benefit one of the major political parties over the other, but they shouldn't be deterred from acting because of the implications on politics either. Indeed, in my view, if the SEC chooses not to adopt rules in this area because they're concerned about political effects, that decision, rather than the choice to adopt rules, would reflect an inappropriate consideration of politics. I think the SEC should focus on what investors, not politicians, want. And when it does, it's going to find that the case for disclosure in this area is very strong. I'm going to be very happy to answer any questions all of you might have, and thanks again for being here today. But first, I want to turn to my colleagues on the panel. Thank you very much.
Hello, my name is Patrick Doherty. I'm Director of Corporate Governance for the New York State Controller. I have some materials here to distribute concerning our fund. I'd like to start with a little bit about our fund. The New York State Common Retirement System, with $161 billion assets under management, is the third largest pension fund in the United States. We have more than 1 million members, retirees, and beneficiaries in our system, and the fund is managed by an elected official, our New York State Controller, Thomas DiNapoli, who is also the sole trustee. We hold approximately over 1,800 U.S. companies, U.S.-based companies in our portfolio, and given the size of our fund, we are in the top 10 or top 20 ranking of shareholders in most of those companies, which gives us considerable clout with those corporations. Corporate political spending disclosure has been a high priority agenda item for our fund since the U.S. Supreme Court's 2010 decision in Citizens United. In fact, we had our first internal meeting on this issue the very day that the judgment came down, and the controller made a determination that it would become a high priority of our corporate governance work. Our primary concern here is that expenditures of corporate funds for political purposes may not necessarily be in the best interest of shareholders if there is a misalignment between the personal or political interests of management and the long-term interests of the company. For example, a CEO may want to become Treasury Secretary one day. So also political spending is inherently controversial and can pose reputational risks for corporations. Justice Kennedy, writing in the Citizens United decision, noted that shareholders have a valid interest in political spending, which can create risks to shareholder value. Full disclosure, he said, will allow shareholders to properly weigh those risks. And I quote, prompt disclosure of expenditures can provide shareholders and citizens with the information needed to hold corporations and elected officials accountable for their positions and supporters. Shareholders can determine whether their corporation's political speech advances the corporation's interest in making profits, and citizens can see whether elected officials are, quote unquote, in the pocket of so-called moneyed interests. He also said that through the workings of, quote unquote, corporate democracy, which is something of an oxymoron, actually, shareholders would be able to object to spending that they found problematic and that they felt were not in the long-term interests of the company. Accordingly, the controller has written to hundreds of portfolio companies asking for disclosure of their political spending. Controller DiNapoli has also asked the SEC for rulemaking to require corporations to disclose their political spending. And our fund is active in several NGOs promoting political spending disclosure. In 2013, our fund filed over 20 shareholder resolutions, disclosed all direct and indirect political spending, and we have been able to reach agreement with a number of major corporations this year, including PepsiCo, Harley-Davidson, KeyCorp, Southwest Airlines, and Dr. Pepper Snapple Group. Now, while this approach has been fairly successful for us, it has its limitations. As I mentioned earlier, we have over 1,800 U.S. corporations in our portfolio. And the workings of shareholder democracy do not realistically allow us to send 1,800 representatives to 1,800 annual meetings each year. This is an issue that really cries out for a federal, national approach. It cannot be left to shareholders, as Justice Kennedy presumed. Now, we also this year have begun a new initiative, so-called books and records requests. Section 220 of Delaware corporate law gives investors in Delaware corporations the right to inspect the books and records of any Delaware incorporated company for a quote-unquote proper purpose, our proper purpose being our fiduciary responsibility to assess investment risk. Significance of taking these actions in Delaware is that 63% of all Fortune 500 companies are incorporated in the state of Delaware, and over 50% of all publicly traded companies in the United States are Delaware corporations. If we are able to successfully establish our books and records rights with respect to corporate political spending in the Delaware courts, it would set a precedent that would enable any investor to obtain a full disclosure of political spending for the large majority of U.S. corporations. It would also be a game changer nationally and would go a long way towards reversing some of the negative effects of the Citizens United decision, as well as fulfilling our fiduciary responsibility of helping to ensure that corporate political spending is undertaken for the purpose of advancing legitimate interests of the corporation and its shareholders, rather than the private personal interests of its top executives. Once again, in summary, this is an issue that we are going to be continuing our focus on, but it is an issue that requires a national answer. It cannot be adequately answered by shareholders, however active and determined we may be. So therefore, we have very strongly requested the SEC take action on this issue.
Thanks to Public Citizen for the invitation to speak here today. I'm John Coates from Harvard Law School. When Liz Warren was at Harvard, I often found myself disagreeing with her. She was a very argumentative and opinionated woman, as she still is. On this issue, I'm delighted to say I'm completely in agreement with her on the issue of corporate political spending, and I'm delighted to be able to support Senator Menendez's bill as well. I'm going to focus my remarks on research, which is my focus. I'm a corporate law scholar. I'm not a campaign finance guy. I come to this from the securities law perspective. I come at it from the perspective of thinking about laws and regulations that the SEC has long traditionally had within its purview, and what makes for good regulations and what not. Corporate political spending across the board, the research finds, is relevant to shareholder value for public companies. There is no one, not even the Wall Street Journal editorial board, who disagrees with this. In fact, in their editorial attacking my research, for which I thank them, nothing like good press, they claim that political spending increases shareholder returns by 2 to 5%. Shareholders care when something affects returns by 2 to 5%. I submit to you there's no area of SEC rulemaking where if you had evidence consistent with the journal's position that an activity could affect returns by 2 to 5%, that there would be no disclosure. There's no area where the SEC has not already intervened on that kind of an issue. Now, my own research suggests that at least for non-regulated companies, the companies that are most politically active tend to have lower value, not better value, but that's another reason that shareholders would want to be able to know what companies are doing with their money in the political arena. And moreover, their spending went up after Citizens United, the observable spending, the disclosed spending through PACs and through registered lobbyists. And as a result of that increased spending, their value fell even further, relative to their own competitors, relative to their own industry peers who are not politically active. That's my research. But again, put aside mine, forget the debate on whether it's good or bad, as Professor Jackson has already pointed out. All you need to know for this rule to make sense as a policy matter is that politics is risky, that it creates risks for investors, And investors need to know what those risks are in order to make reasonable investment decisions. Again, there is no debate that political activity can be risky. If it's reputational hit as a target, if it's politically motivated or inflected investments. My favorite example here is AT&T's attempt to buy T-Mobile, which failed because of a political strategy to try to get antitrust enforcement changed. The result of that failed strategy was a $6 billion payment to Deutsche Telekom. I submit to you most shareholders would like to know when their money is being bet in a political way that can have a downside of $6 billion for a single transaction. There is nothing in AT&T's 10K that preceded the annual report that preceded that acquisition that warned investors that it was thinking about making those kinds of politically inflected bets. Last point I'll make is there is also an SEC reason for adopting this rule for the reason of governance. As Professor Jackson alluded, the managers who run these companies have their own interests. 20 to 30% of retired CEOs of S&P 500 companies go on to get political offices after they retire from business. Let that sink in. 20 to 30% of the country's largest companies go on to become senators, to become treasury secretaries, to become chair of the SEC, to become ambassadors. They have their own reasons for using other people's money to make political investments that will pay off for them personally. And those motivations usually, at best, will have nothing to do with shareholder interests and often will be opposed to them. And this isn't just the dollars spent on political activity that Professor Jackson alluded to. It also reflects different strategies at the business level, different projects that they invest in, different decisions about where around the world to invest and how to invest. All of these things matter to shareholders intensely, and they matter in ways that are really important to the bottom line. The idea that those kinds of decisions is not material to a shareholder is, frankly, on its face, laughable. And it's only an elected official or someone who wants to be elected who could make that argument in good faith in a room full of securities lawyers. The last thing I'll say is on something about the politics of this, and I know it sort of hangs the politics of the rule itself, as Professor Jackson already alluded. This is something that affects the way people are thinking about it as a matter of policy. Here's what I'll tell you. This issue is not going away. Dark money is going to get bigger and bigger and bigger. There is no reason to think otherwise. As it becomes more and more important, the political demand for some type of disclosure will grow and grow. And here's my real promise to you. The next time there is a GOP president, and therefore a GOP chairman of the SEC, that chairman will find it politically impossible not to do something. And therefore, if that's going to happen, then the current chairman ought to take seriously the job of doing the right thing as a policy matter without regard to politics. It's coming. Thank you.
I don't have a PhD like my two predecessors here, but I've followed shareholder resolutions for a long time. As Lisa said, I'm Heidi Welsh, Executive Director of the Sustainable Investments Institute, and we get our funding from educational endowments and pension funds. And we also do reports for the public, and a couple of years ago I did a couple of studies looking at what the S&P 500 are doing with respect to corporate governance of political spending and how much they're spending. So today I'm going to provide some context for the SEC and others to consider when they're looking at this proposed rulemaking process. I'm going to show you, go into a little more detail on how shareholder proposals about political spending compare to other shareholder resolutions, touch briefly on another point that has not been mentioned about how political spending has come up in the work of a group called the Sustainability Accounting Standards Board, which is redefining the concept of materiality, and the SEC is part of that consultation process. And third, I'll note that recent increased attention from the Carbon Disclosure Project which is an international group interested in climate change and companies' involvement in public policy. It's noteworthy because CDP has backers of asset managers who collectively manage $87 trillion, which is a large proportion of the world's investable capital. So first to shareholder resolutions. Since the early 1970s, investors have used shareholder proposals to ask corporate boards to address current public policy issues. It's usually the issue of the day, and it comes up in corporate annual meetings. Most of these ask companies to provide more information. In the last 10 years, support for these proposals has doubled, reaching about 21% in 2013. And I have some nice graphs and charts that were out there in the hallway. Investors file about 400 social and environmental proposals every year, and about half of these go to votes. About 40% of them end up getting withdrawn after agreements between the companies and proponents of the investors, and the rest get thrown out because they don't meet the provisions of the shareholder proposal rule. There's been a campaign for companies to release more information about their political spending since 2003, a long time before Citizens United. That's when the Center for Political Accountability began its work. It's a DC nonprofit that works on disclosure issues on this subject. Although additional shareholder proposals have surfaced over the year, the overwhelming focus has always been on disclosure. There are a few that talk about stopping spending, but really the main tenor of these resolutions is disclose more information. Here's a couple of facts to just throw at you quickly, and then I'll explain what that means. So since 2010 and Citizens United, the number of all political spending proposals filed has doubled, and there have been 332 separate proposals on disclosure alone. Proponents have withdrawn about a quarter of those, mostly after the companies have agreed to those requests. The number of disclosure proposals voted on has also more than doubled. The resolutions on political spending make up about 40% of all the social and environmental votes in 2013. That's the biggest single issue category for this year. The support for oversight and disclosure resolutions that are championed by the Center for Political Accountability has averaged about 30% over the last 4 years. So what do these votes mean? While these generally aren't majority votes, company boards nonetheless pay very close attention to them. Shareholder resolutions for a long time have served as a barometer of current investor sentiment, and directors rarely ignore votes greater than 20%. And in the environmental and social space, only requests for sustainability reports, board diversity, or EEO earn more than those on political spending, and there aren't nearly as many proposals on those subjects. More companies, therefore, have started to adopt greater oversight and disclosure following advice from the Conference Board's Committee on Corporate Political Spending, whose participants include some of the biggest companies in the country: Coca-Cola, Merck, Microsoft, and others. A total of 118 companies have reached agreements with these investors so far on disclosure. So there's a lot of voluntary uptake. A key unresolved sticking point that we have talked about here that I think is going to continue to be unresolved for some time is how much companies should disclose about their indirect political spending. Not just giving directly and above board, but indirectly, the dark money issue. Money that goes to trade associations and other nonprofit groups that spend on politics, both on lobbying and in campaigns. And any SEC rule will have to determine the boundaries of disclosure and how much information investors should have, considering the very different views that the partisans hold on this. So 2 other quick points. We don't have time today for a more in-depth discussion of how companies and investors are reconsidering this concept of materiality, but when the SEC makes rules, this is a central consideration. It must determine what information a reasonable investor needs to make informed investment decisions and what factors affect the total mix of available information. And as it moves forward, the SEC will want to look at how a group called the Sustainability Accounting Standards Board, or SASB, is considering political spending. It's consulting in a pretty collaborative fashion with companies, investors, and other experts to expand the definition of materiality so that it will include environmental, social, and governance factors that affect long-term value creation, since about 80% of corporate value is not accounted for in traditional accounting practices. SASB's assessment of leadership and governance factors includes consideration of corporate political contributions and lobbying.
So my final point speaks to whether there's other evidence of investor interest. The Carbon Disclosure Project, or CDP, is backed by institutions, as I mentioned earlier, that collectively manage $87 trillion in assets. CDP annually requests the world's largest companies to report on climate change management and carbon emissions. Lately, CDP has become more interested in corporate influence on politics, given our inability collectively to come up with a way to address climate change. And in 2013, CDP expanded questions about public policy, asking companies to explain in more detail how they directly engage with lawmakers and how they fund trade associations and other research groups. Again, the issue of dark money. This request really illustrates, I think, important investor interest in how companies are taking part in the political process. So in conclusion, I think it's abundantly clear there is substantial investor interest in corporate political spending disclosure. The flood of shareholder resolutions, the relatively high votes, and the subsequent company responses really underline this. Respected groups such as SASB, which are not partisan, are redefining and expanding our understanding of material business risks, including political spending, and investors working with CDP, who control a significant portion of the world's investment capital, really want companies to explain in more detail how they are spending money on politics. And I have some, as I said, some charts and nice graphs and so forth that are out in the hallway, and I'd be happy to provide them as well to anyone who's interested.
Good afternoon. I'm Laura Berry, and I am batting cleanup today because no one wants to catch the bug that made my voice sound like this. So pardon the Looney Tunes voice. So I want to say thank you to Lisa and to Public Citizen and to my esteemed panelists and co-presenters. I'm especially grateful to Senator Menendez and Senator Warren for their support as we continue to make the case for SEC rulemaking to require corporate political spending disclosure. I'm delighted to be part of this groundbreaking coalition, one that has brought together so many investor voices from all political ideologies. As we encourage the Security and Exchange Commission Chair, Mary Jo White, to make corporate political spending disclosure a true priority in the SEC's rulemaking. Because I join you today in my role as the Executive Director of the Interfaith Center on Corporate Responsibility, I want you to understand a little bit about the investors that I represent. We are the nation's pioneer coalition of active faith and values investors, and for over 40 years, our members have built an enduring record of demonstrated influence on corporate policies. Policies that are intended to promote a more just and sustainable world, as well as create investor value. We've consistently practiced what we preach, ensuring the perpetual public availability of information about the issues our members take on, as well as the identity of the companies that we engage. In fact, even archival material from the pre-internet days is readily available, thanks to the fine work, I must say, of Columbia University's Rare Book and Manuscript Library. In short, throughout our 43-year history, we have occasionally lost some friends, but we've never found our influence or our judgment as investors to be diminished by transparency. Although I'm speaking from the perspective of the institutional investors who are part of the ICCR coalition, it's really hard to imagine any shareholder or voter who would not support political spending disclosure, given the interplay between our democracy and the many critical issues companies and their investors face. In my years of experience as a large cap value investment manager in the 1980s and the 1990s, remember those days? More information was always better for investors and their investment managers. So when companies are reluctant to disclose their spending in the political arena, one can't help but wonder why. Why is it that the additional disclosure to protect our marketplace and our democracy is challenged by some companies? Why, during what is arguably the decade of big data, do companies resist political spending disclosure? Further, how is it that a company's business projections rely more and more on sophisticated streams of customer behavior and spending data, yet the political spending disclosure that their investors need is considered burdensome? I find these questions perplexing. Perhaps you do too. ICCR's 300 plus members with combined assets of more than 100 billion represent religious denominations, public and private pension funds, foundations, and investment management and analysis firms. Our work is linked by the shared belief that as prudent long-term investors with responsibility for many generations of future beneficiaries, we must act as catalysts for change while ensuring solid investment performance. To create value and meet our responsibilities as investment fiduciaries, investors consider a lot of factors when making buy decisions. As prudent investors, ICCR members always consider the content of a company's stated policies and values very carefully. We need to understand whether a company's political spending is in line with those policies and values. The materiality of that alignment of policy and practice is clear. There have been numerous examples of misalignment creating material risk for investors, and some of which have been cited already today. When these inconsistencies are brought to light, the risk to a company's reputation and brand is immeasurable, and investor value is lost. But as long-term investors, we see a far, far greater risk, and that is a systemic risk when disclosure is limited or non-existent. Are there companies who have made a commitment to voluntary disclosure? Absolutely, and we celebrate those companies. Disclosure is one way that well-managed companies demonstrate the consistent alignment of policy and practice, building value for their investors time and time again. In the SEC's charge to protect investors and to preserve the integrity of our markets, uniform disclosure standards are essential. Voluntary disclosure, while important, is not sufficient. We have urged Commission Chair Mary Jo White to act now to require disclosure. I keep changing this number. I started with over 500,000 public comments, then I changed it to 600,000, and today I had to change it to 643,000. With 643,000 public comments, it's clear the case has been made to some folks. It's time to require that public companies provide disclosure to shareholders regarding the use of corporate resources for political activities. I'll end my remarks with just a few open questions. Are there companies that have publicly celebrated their commitment to vulnerable neighborhoods while allowing underwriting practices to erode, contributing to the near collapse of the global capital markets just a few years back? Have there been companies who publicly celebrate a commitment to the environment while funding research to undermine the evidence of climate change? Are there companies who profess a universal right to health care access while supporting industry groups who work diligently to prevent that very same access? Investors are already asking those questions. The new rule might allow us to, at long last, have answers. Thank you for inviting the Interfaith Center on Corporate Responsibility to participate in this important conversation, and I look forward to any questions you might have.
Well, thanks so much to the panel for their thoughtful presentations. Now the floor is yours. We're open for questions. There's a microphone in the middle. Folks should come on up.
I'll start with one.
Sure. Right to the mic.
If I don't have to go to the mic, I can speak very loudly here. We've seen a fourfold increase in outside spending immediately following Citizens United in 2010, and another fourfold in 2012. But given that dark money is dark, do we actually have any reliable indicator how much is corporate money? Do you have any numbers, something like that?
The answer is that we don't know what we don't know, all right? For example, it just came out last year, and it was inadvertent, that Aetna had given two gigantic contributions of one over $3 million and another one over $4 million. $3 million was to the Chamber of Commerce, National Chamber of Commerce, for the purpose of political spending on campaigns, etc. And another $4 million were given to a political action committee run by former Senator Norman Coleman, which was involved primarily in negative political campaigning against members of Congress, both Republican and Democrat. It was actually sort of they were involved in primaries against Republicans and that they didn't like, and they also were involved in general election against Democratic candidates. And these were contributions which were enormous, which sort of dwarfed the other contributions that Aetna made. And Aetna did not intend to make them public. It was an accident, the company said. They were put on there was an insurance disclosure form that had to be filled out, and they accidentally, as they say, put these contributions, they disclosed accidentally. And so this may be the tip of the iceberg. All right, here were enormous contributions by a major corporation, and no one knew about them, and no one would have known about them but for an accident. So what else is going on? No one knows. We don't know what we don't know.
Just to briefly add, and so the question was, given the very significant increase in spending since Citizens United, do we know how much corporate political spending is actually happening? And the short answer to that question is no. And anybody who gives you any other answer is wrong, because there's no disclosure that could help us get at those data. Now, Professor Coates has several studies that uses what data we have, and I presented some very preliminary data based on some other information. But the short answer to your question is no, and I want to just note that many of you have heard today a discussion about materiality. Many of my colleagues on the panel have talked about, is this stuff material? And the reason you're hearing that is one argument against the proposal is, this stuff's not material, so shareholders don't really need to know about it. And I'm puzzled by that claim, because it's actually literally impossible to know whether it's material since it's not disclosed. So I think one challenge that we have as a group that cares about getting this information out there is to do what we can to shed light on the spending we know about. Because as my colleagues have said, that may well be the tip of the iceberg. And showing the SEC that the extent of the magnitude of this issue for shareholders might be very considerable is going to be one of many ways we'll persuade them to do the right thing.
Yeah, I have a question on indirect spending and the magnitude of it with trade associations. I believe the National Association of Manufacturers, Chamber of Commerce, and Business Roundtable have issued letters kind of against political disclosure. And I think the Chamber has spent over $1 billion since 1998 on lobbying. Could you, the panel explain a little bit more about the magnitude of indirect spending and trade associations and kind of where that money comes from?
Well, I can talk about the structure of it. So John is talking about both campaign spending, and lobbying, they are handled by different laws. And as I said in my remarks, if the SEC decides to take up this rulemaking, it will have to determine what the boundaries are of the disclosures. With respect to indirect spending, I have not studied that in detail to put specific numbers on it. But the way it works is that trade associations and other nonprofit groups that can spend money in politics have to report back to their members on what are called non-deductible expenses, the amount of money that they spend in the political system, either for lobbying or for campaign spending. So that's a known proportion of the amount of dues that these organizations use, and they know what proportion it is, and they report that back to the companies. So I guess that speaks to the question of whether or not companies can know how much of their money goes to that. And you can also look up on the IRS Form 990s, which are annually filed, to find out how much of those organizations' activities are spent for political purposes. So from that, you can infer some figures on that. But I don't have a specific number for you.
Trade association payments by corporations are largely exempt from any reporting requirement. The trade association does have to report back privately to the company as to what portion of the payments the company made to the trade association were used for political purposes, but there is no requirement whatsoever for any of that to be made public.
Next one, come to the mic.
Thank you. I'd also like to know a bit more about, if the SEC rule that they're considering and the bill that is being proposed by Menendez, are these going to cover primarily corporations, or are they also going to cover some of the pass-through entities? Because my understanding, after reading the Washington Post just this last Saturday, is that really only a minority of the let's say corporate business tax revenues are being generated by corporations, and more businesses, and this was also brought up in The Economist just on Friday, more and more businesses are turning themselves into various sorts of new pass-throughs. So I'm wondering, even if we win on these things, how much progress will we really have made?
So, I mean, the SEC's purview is companies that have dispersed shareholders, more than 2,000 as a result of the change last year, or if they're listed on a stock exchange. That would include pass-through entities. So if there are, for example, many oil partnerships that have publicly traded pass-through interests, those would be covered. But if you're talking about closely held limited liability companies owned by one or a small number of people, those would likely not be covered. And so I think your question raises a very important point, which is that the public voter citizen interest in disclosure is broader than, and in some ways more important, probably for the long-term health of our overall economy and polity, than the issues we're talking about today. The issues we're talking about today, nevertheless, are within the SEC's existing authority. Congress does not need to act, and are independently important. They're things that should be done regardless of whether the FEC, Congress, the FCC, or any other agency that has some relationship to political spending can muster the political will in the short run. That would be my answer.
That's absolutely right, and I'll just briefly add, keeping in mind your very important point, I think Professor Coates is right to say that the public interest in this question goes far beyond the scope of our proposal. But keeping in mind your concern, our petition does make clear our view that the SEC should require public corporations to disclose whether they gave money to intermediary entities, and if so, what the likely political spending is that resulted from that from that spending. So we do attempt to capture the extent that public shareholders' money is used for a purpose like that. Well, I think our proposal would capture it, but as Professor Coates says, there would be lots that we didn't capture, and our goal is to get the SEC to act based on its existing authority.
The other thing I think it's important to note is you have to differentiate between PAC spending, individual executive spending, and corporate spending. And the petition is really for corporate spending, which is the shareholders' money. Now, big CEOs of major companies or private companies can spend very significant amounts of money on their own. That's not shareholder money, and that's not what this petition is about. That is handled separately, and there's been some recent litigation on that issue. But really this petition is focused on the investor piece of it and whether or not investors who own companies and own the stock in the companies, if their money is being used in a way that is not disclosed.
Other questions?
This is a question for Professor Coates. You said something intriguing toward the end of your remarks, that the SEC under this administration, under the leadership of Mary Jo White, should get moving on this rule because you speculated under a Republican administration the SEC would adopt a corporate political spending rule. Could you just elaborate on why you think so?
Yeah, it's a bit like Nixon going to China. The Republican chair, when that person eventually is, I suspect eventually in my lifetime there will be another Republican president. I'm a registered Democrat, so I'd like to think not, but nevertheless there will. When that happens, the chair of the SEC will be a Republican appointee. A Republican appointee standing up and defending corporate America on the ground that they're entitled to spend other people's money in secret, I think has a different political valence and is much more difficult to sustain than the Democrat one. I mean, that's the point. It's just a pretty straightforward point. I just think the politics of it will be worse. In addition, by the time that happens, the amount of conduit money, dark money that was just being discussed, that's available, we'll be able to at least see FCC purchases of broadcast political ads, and we'll be able to see the 990s from the nonprofits. It's going to keep growing. And so the result of those two things means that eventually this some rule in this category will be adopted. And then the question is, from the perspective of somebody who is advising the current chair, is it better to take on that issue now, even though it's politically fraught? I mean, I think everybody should acknowledge that it's not exactly going to be the most popular rule for the SEC to be pursuing, given the partisan nature of the controversy that's going to surround it. Nevertheless, it's, I think, going to happen.
This is for Professor Coates or anyone else that does the money and politics research. Prior to Citizens United in the 2008 meltdown, I'm sure there was a lot of political money to decrease regulation of the financial sector and decrease sunlight. And clearly, that was a debacle for shareholders. I just looked at the price of AIG over a 10-year period. I mean, it was ridiculous. There's so many companies that just killed shareholders. That crisis was so bad for shareholders, and it was really darkness that brought that about. And I was wondering if you could talk about what you see the impact of the increasing rise of dark money on shareholder value, especially in the financial sector.
Yeah, no, it's a very good point. The focus of my research, and I think of many people who come to this issue, is less about the dynamics between undisclosed spending and regulation more broadly, and more about just the actual use of the money in the current moment and its effects on shareholders. But you're raising a broader issue, which is that when political spending and political activity generally is capable of being kept secret, you would tend to expect the outcomes of that process to be worse for the public more generally, and that would also be bad for companies. It would be bad for business. It would be bad for shareholders. I think it's no coincidence that the two countries in world history who've done the best for their, by way of economies, have been the United Kingdom, the United States, and then affiliated entities. And those two countries have long had traditions both of transparency in the investor sphere and of transparency in the political sphere. The United Kingdom already requires listed companies to disclose all of their political activities and to get shareholders an opportunity to vote on that. So anyone who makes a claim that there's an inconsistency between capitalism broadly and either regulation of this kind or regulation or disclosure of political activity has to explain away why the world's second most powerful financial center has already gone past us on this.
We see if a voice comes out. I'd like to just add to Professor's comments. I think thinking about the capital markets collapse in 2008 and thinking about the sort of incredible arc of both technological capacity, computational capacity, data capacity, analytical capacity, and our ability to create, because of that additional capacity, more and more opaque financial models. I think that the 2008 debacle was the clearest example of why at these times of transition, Jacques Barzun talks a lot about 500-year cycles to human history. And I think, if we are in a technologically data-driven cycle, it is absolutely essential that our influencers don't get out ahead of actually understanding how this new capacity works and what new systems need to be installed to make sure that we don't blow the whole thing up. And so I think particularly at this technological inflection point, it is absolutely critical to have much more disclosure around anything that influences public policy.
And I was just going to add one thought. I think the question really, larger question is, is political dysfunction, which a lot of folks on the Hill are experiencing every day, is that good for business? And if it's not, as the recent government shutdown might suggest, then what moderating role might corporations play in sort of pulling us back from the brink of dysfunction, and how much does sort of corporate political spending create a more functional politics or not? And those are sort of abstruse questions, but I think they get at some of the sort of underlying drivers to this debate.
So I think we have time for one more question.
A lot of critics of this rule say that it doesn't fall within the SEC's domain. How do we respond to that criticism?
So I'd say a few things about that. So you could make this argument. That argument takes one of two different forms. The first is just that the SEC lacks authority to require disclosure of this kind of stuff because they can only require disclosure of things that are material, and this is not material. We've talked about reasons why that argument, in my view, is just not sustainable. There's no data to support this argument. In fact, if you look at other areas where the SEC has already required disclosure, they require disclosure, for example, of executive compensation of relatively small amounts. So even if you don't believe that the amounts are large, they can require disclosure of these kinds of things. So for instance, the SEC requires companies to disclose when a CEO gets on a plane and it costs $30,000. For the CEO of IBM, that's not a very significant number, but they require disclosure of it. And there's no doubt that that rule is valid. So I think there's no real question that based on amounts, this meets the standard for materiality and the SEC has statutory authority to do it. So this argument can take one form, that is the form that they just don't have the power on materiality grounds, but this argument's not a winner. There's a second version of the argument you just described, which is that the SEC should just not get involved in things that have to do with politics. So this is an argument that Congress should do it, or the Federal Election Commission should do it. And as I hinted in my remarks, the reason this argument doesn't make much sense to me is that that is not the job of the SEC. To guess whether giving investors the information they need is going to have a political effect. Whether or not giving investors the information they need has a political effect, the SEC's job is to make sure they get that information. And for me, a failure to do a rule because they're afraid of political effects is actually the only way they can improperly consider politics. Because in my view, the SEC should evaluate our arguments about whether this is important to investors. If it is, it should be disclosed, and if it's not, it shouldn't. But whether or not it has any effect up on Capitol Hill should be neither here nor there.
Well, thanks so much to our panel. They'll stick around for a minute to answer other questions, and thank you all for being here today.